Hello, my name is Margaret Schaefer, and I'm an attorney at Legal Aid of Nebraska. Legal Aid of Nebraska is the law firm that provides legal assistance for those in our community that are low income or elders or other special programs. Today, we're going to talk about advanced directives. Advanced directives are also known as living wills. And what I want to help you to know more about is why it's good to do this now. The sooner the better. Because if you wait too long, you're going to have maybe some issues, and we want to prevent that as best we can. So the first thing is to know what it is we're talking about. An advanced directive is just a writing that says the kind of care that you or your loved one, whoever's signing it, might want if you were terminally ill or in a vegetative state and not expected to recover. You can state the sorts of care that you might want under that circumstance. So for example, would you want artificial hydration or nutrition? Would you want some kind of breathing mechanism, generally thought of as tubes and machines? Or would you rather not have those interventions? One of the things that's very important when you're setting out an advanced directive of the kind of care that you might want is that your family understands the values that are behind them. Because it's impossible for any of us to fully anticipate the questions and circumstances that might come up. And by then, we're not able to answer questions about what kind of care we might want. That's why we need to write it down, but you're caught in this situation of not always knowing what or anticipating what it is that might happen. The other part of an advanced directive or living will is a healthcare power of attorney. The healthcare power of attorney is your opportunity to say who speaks for you when you can't speak for yourself. You're designating another person to make those healthcare and medical treatment decisions for you when you're not able to do so. Now, the advanced directive and the healthcare power of attorney are generally in one document, commonly called a living will. And there are many forms and ways to get that. And we're going to talk a little bit more about how to get one in a moment. There are some things that are required in your healthcare power of attorney. One, it must be in writing. If I just tell my doctor, I want my husband to take care of things for me, that's not a healthcare power of attorney. It needs to be in writing. It must identify the principal. The principal, that's me. I'm the person signing it because it's my wishes that we're talking about. It needs to identify the attorney in fact. That's the agent. That's the person that's taking care of these decisions for me. And it should designate a successor agent or attorney in fact. We always think that folks are going to have a linear kind of existence and that our children will outlive us. And so I can name my husband and then my child and then however, but sometimes things don't happen the way we plan. So having a successor just in case is a really good idea. The document must also specifically authorize the attorney in fact to make those healthcare decisions if I or the principal become incapacitated. It must be dated, and it must be witnessed either by two people or by a notary public. And when I'm saying witnesses, it can't be people who are interested. So the agent can't be a witness. It needs to be uninterested, somebody who's not involved. It's usually easiest to go to a notary. You can find one at a bank, usually, that can notarize your signature. Now, not everyone can be your agent under a power of attorney. Your doctor cannot be your agent. We go to our doctor for advice about the treatments and their consequences. And they are a wealth of information, but the doctor is an information source, not the decision maker. also cannot be an employee at the doctor's office, like their nurse or receptionist or physician's assistant, unless they're related to you. So if the nurse at the doctor's office happens to be your sister, she can be your agent. But if she is an employee that's not related, then no. Same with an employee at your nursing home or assisted living facility. It's called a conflict of interest. We want to avoid those. There are perhaps folks who serve as a healthcare power of attorney for many people. They can't have more than 10 people that they're serving as a healthcare power of attorney agent. That helps to make sure we don't end up with people that are serving as agent for many, many, many people and not able to effectively take care of the folks that are within their charge. Now, a healthcare power of attorney does not go into effect until you are incapacitated. So what that means is the doctor needs to say that you're no longer, as the principal, able to make your own healthcare decisions. And this may happen for very obvious reasons, or it may be a little more subtle. For example, we've all learned in this time of COVID that sometimes people get very, very ill and they may end up needing to be on a ventilator. If someone's on a ventilator, they are sedated. That doesn't mean that they have no, that they might not be okay later and be able to take care of their own business. And certainly they hopefully could have made decisions about what healthcare they wanted prior to being put on a ventilator. But while they're on a ventilator, they can't talk to anyone. They can't make their wishes known for what next steps or what kind of care that they need. So they are incapable, and the healthcare provider would look to their surrogate, look to their agent, look to someone else to make decisions for them about their next levels of care. So it's the doctor that will identify that you need to have someone else making your decisions. This is not a permanent state. So if the person who's on a ventilator comes off of the ventilator and regains their ability to communicate and regains their ability to make their own decisions, they're back to being the ones making the decision for their own healthcare and their needs. It's a contingency. That's a legal term that just means that the power of attorney for healthcare only has authority during the time the principal is unable to exercise their own personal authority and make their own decisions. So sometimes people will tell me, I don't need to have any kind of a power of attorney, healthcare power of attorney, or any other kind, because I'm perfectly capable of making my own decisions. Well, that's true for today, but I hope we've all seen that that isn't always the case. And once someone loses the ability to communicate or loses the ability to make their own decisions, it's too late. So what happens if you don't have one? If you lose the ability to make medical decisions, if you have a stroke or get COVID on a ventilator, something like that, and you don't have someone to make decisions for you, there are some statutes in Nebraska that can help to say who the next person would be, maybe your spouse or a child, but that's not within your control. The other thing that sometimes needs to happen is a guardianship needs to be established. So we find folks in a hospital without a surrogate or anyone to speak for them. And the hospital needs to then file for guardianship to have someone appointed by the court to help make medical decisions for this individual so they can get whatever that next step care might be. And in the meantime, the hospital is very limited in what they can do. So it's very important that you have a power of attorney for healthcare already signed and taken care of before you ever need it. My recommendation is that any adult should have these documents prepared and ready and in a safe place, just in case. Now, for most of us, those documents will become old and yellowed and never be used. That's wonderful. That's the best. but if they're needed, we want to make sure that they're there and available. How do I get one? Healthcare powers of attorney are readily available oftentimes when you go into a hospital, but you don't want to wait that long and you don't want to have that issue to take care of if you should be hospitalized. If you or the principal, whoever it is that needs one, maybe this is for a mom or a sibling or somebody, if they're 60 plus, they can call the Elder Access Line at Legal Aid of Nebraska. That's 1-800-527-7249. The paralegals on the Elder Access Line will answer any questions that the person has and provide the forms for them to fill out. Now we need to talk to the principal. We're not able to talk to a third party who wants a power of attorney, healthcare power of attorney over someone else. That's not possible. We have to talk to the principal themselves to explain what the document is and make sure that we've answered all their questions. We also have some resources available on our website at legalaidofnebraska.org. Poke around there and there are some forms that will help you to get a healthcare power of attorney established. So now I have it. What do I do with it? The healthcare power of attorney should be kept in a safe place. On the Elder Access Line, we get calls from people all the time. And they say, I know my mother signed this document, but I can't find it. If you don't have the healthcare power of attorney or a copy, copies work great, then you don't have it and you may need to file a guardianship. You can give a copy to the agent. I have given a copy of my healthcare power of attorney to my son. So if there was an emergency, he would be able to speak on my behalf. I also give a copy to a trusted friend or family member, and I could give a copy to my doctor so they know who speaks for me and they can see the kind of care that I might want and what my wishes are in that advance directive. Now, I mentioned before that it's important to talk with your family and friends about that care that you might want. What I've found in my own life is that those conversations can come up naturally when things are happening to family members or friends or someone in the paper. You can say, wow, if I was in that situation, I don't know that I'd want to have this intervention or that intervention. Or it's really important to me that you do everything that's possible to give me a chance at life. Whatever that value might be, have the conversation. We always knew what my mom wanted before she passed on because she told us, and she told us all the same thing. She told us together. She told us individually, and we had conversations throughout the last 10 or 15 years of her life so that we knew when my sister, who was her agent, made decisions, she was following mom's wishes. Mom's wishes were carried out to the very end by her daughter, my sister, and she was cared for in the very best way. So if we can answer more questions about healthcare powers of attorney, please contact the Elder Access Line at Legal Aid of Nebraska. If you're 60 years of age or older, we're happy to answer those questions, talk with you about any of these issues and help you to make sure that you have the forms that you need so that you receive the care that you need at end of life or in any kind of illness. Thank you very much.